Hello, everyone. Thank you so much for joining us today. This is the ninth legal system seminar hosted by XKDR. We seek to do this every month. We've been doing this for the past 8-10 months. If any of you or anybody you know would like to present in any upcoming seminars, please do let us know. As of today, we have two presentations, one by Siddarth Raman on approach to evaluate court reforms, and the second by Karan Gulati on arbitration at the Supreme Court, unsteady, uncertain, and slow. Without further ado, let's begin.
Okay. Hello, everyone. So I think anybody who's attending this seminar doesn't need convincing that the Indian legal system is broken. The issues have been discussed many times, including in several fora, including this seminar series. Now, there have been many ideas on how we can actually make this better. So some folks have tried creating dedicated specialized courts. Say the traffic challan court is one example in Delhi. There are special 138 cases relating only to check bouncing in various states of this country. There is an e-courts phase 3 project that says, look, better IT systems will make all the difference. Some folks say we need more judges. We recently saw a change in law, and that's supposed to make things better. We discussed ICTS, the idea of an Indian courts and tribunal service that might, help matters by separating judicial and administrative tasks. The question that we must hold is, okay, we can try out any of these ideas, but how do we know whether an idea is working, right? If you actually put in place any form of intervention, how can you actually be sure that this is yielding results? The specific context which we have approached this problem is, some of you may be aware that this month the Kerala High Court launched On Courts 24/7. It is a new type of court in the district of Kollam. It is a magistrates court dedicated to solving check bouncing cases. We as XKDR are part of a larger collaborative called Pukar, who have been sort of knowledge partners to the court in setting this up. And it brings with it a new IT system, no doubt, but some other process interventions have also been implemented. One, to separate some elements of administrative and judicial tasks. It allows for virtual hearings, asynchronous modes of communication. We're having a two-way system so that not only does the court speak to litigants, but litigants and lawyers can also reach out to the court outside of hearings. Better scheduling systems have been considered, a better e-filing system. And this is built on multiple hypotheses based on conversations with users and stakeholders. But we must ask ourselves, as the Kerala High Court or as anybody in charge of such a system, how do you actually assess whether these interventions are working, and how do you keep improving them? So we understand that it is impossible to assume that your idea will work on day one. When the rubber hits the road and when you actually start dealing with the messy reality of cases in court, that's when you will actually get a sense of what's going to happen. So it's a journey. It's a journey of ideation. It's a journey of iterative refinement. In this journey, it's very important to understand that there is the saying that what gets measured gets managed is almost critical, right? I mean, if you do not know what is actually happening, you can't really figure out whether you're headed in the right direction. And I think all of this is, again, well known to most people on this call, that any process of reform, you must measure. It helps you, get to a quantitative assessment of things. It helps you define the starting point and also the directionality of change. So then you can measure the same things at the start of the journey, along the journey, towards some endpoint. And then to the end of all of this, it also helps you put some numbers to things, validate your diagnosis, and then assess the impact. And finally, ask the question, was it worth it? Like, a lot of investment goes into some of these interventions. And as objective people looking at the state is spending money towards all of this, we must ask, okay, that's great, we tried, but did it really make an impact? Now, we know that a lot of the work in courts is actually process management. The view from the courts is, okay, the judges take decisions, and that's true. But behind it all, there are several input variables that go into it. You need to think of how matters are scheduled, how many matters are scheduled during the day, was the judge present, was the judge absent, were the litigants present, and all of these go into, and how many hours did the court sit, for example. All of these go into understanding the case management system set up by the court. And then as cases go through court, several things happen. People are asked to do some tasks, get some more documents. Sometimes hearings are held, sometimes they're not. And then was the hearing substantive, which did it make an actual tangible progress in the life cycle of the case? And then at the end of the day, a next hearing date happens. And all of this is just process management that happens in courts, which eventually leads to outcomes. We need measurement at all steps of this journey if we are to actually get a sense of how can we make things better, because unless you're aware of where things are breaking, you're not really able to make targeted interventions or make any tweaks. Now, most of our courts don't give you a complete overview of court operations. This is data that is not just invisible to us as outsiders, but this is often invisible to the court themselves, which means if you ask a judge some of these questions, they may not be able to answer them. So there is a lot of limited visibility into the actions of the frontline court staff. And ideally, in an ideal world, you want a lot of details to be able to really dig deep into a system. So why are litigants asking for additional time? Why are adjournments granted? What are the reasons people give for these adjournments? The other interesting thing is, okay, we often track the life cycle of a case in years because, well, that's the data available to us. But what you really want to know is that in terms of judicial minutes, how much time was spent. So we've done some, early work which says that at least for matters like check bouncing, the case is often less than 100 minutes, and that 100 minutes often gets stretched into, 3 years often, right? So, but it's really important for us if we can measure the actual judicial minutes, because that will give us a sense of the fragmentation that happens in a case. Then, which summons is effective, what more. And eventually, if you have all of this data, the hope is the court will be able to make some tweaks. Maybe the court can sit for fewer hours. Maybe you can schedule less hearings in a day. Maybe you can schedule hearings closer together. And you can see, is there any impact on enforcing some amount of court discipline to avoid adjournments? But you cannot do this in the absence of data. So we are presenting to you a frame for thinking about the problem. We call these fine metrics and coarse metrics. So the visualization that you're seeing is that of an F1 car, and you see a system engineer or the chief engineer of Ferrari trying to make tweaks in the engine of the machine. And these are very fine control systems that you can use and modify to make small changes to the parameters. And this is not what we as observers of the system see. For us, we just see the car zoom around at the racetrack and we understand, who won and who lost. So very similar in any system, you have fine metrics that the users and the administrators of the system have visibility and control over. And then we're calling these coarse metrics, which just tells you, okay, what happened, what is visible from the outside. So fine metrics are available within good IT systems. So if you've got a good IT system which does good data collection, capture, and captures it in a format that is analyzable in an easy manner, you will get a lot of good information like how long a case takes in judicial minutes. Does it vary by type of litigant? What is that impact? Is there, do you see some Pareto where 80% of cases are handled by few lawyers? What are the different outcomes? Where there are settlements? What's the settlement ratio? And all of these are things that we'd like to know as researchers, and ideally what system administrators should be aware of, but they don't exist. And the hope is that as our IT systems get better, all of this information will come to light. And, like in the case of Kollam, while there have been interventions which have been introduced, how often do they get used, right? Do people really use virtual hearings? What is the scheduling efficiency? You might have a scheduling mechanism, but unless you have a measurement of efficiency of, how many times did a matter get rescheduled? How accurate was the scheduling? Did it differ by 15 minutes? Were you made to wait for 4 hours? These are details that a good IT system will give you. But most of our courts do not have these IT systems, and it's very unlikely that we're going to be able to get them. So in the absence of fine metrics, coarse metrics are often always useful. So coarse metrics give you two major benefits. One is, in the absence of fine metrics, you can use coarse metrics, but coarse metrics also help you understand how the world sees your new system, where irrespective of the data that you have, there are certain things that the outside world can see. And to define these coarse metrics, we write off the work by Manivanan et al. In 2022, where we take the litigant perspective upon courts, where they had defined 5 metrics: independence, efficiency, effectiveness, predictability, and access. And we take a subset of those metrics to define our course metrics for the purposes of evaluating these court reforms. We argue that these course metrics should be publicly accessible information. So you needn't have to be an insider to actually understand these course metrics or measure them. Ideally, we would like these to be agnostic of case type, jurisdiction, rules of practice, because these are things that will often require you to go sit in court, understand a lot of details, and this is not a fair expectation from anybody trying to study a system. So if as a person sitting in Bangalore, you want to know whether, if the Bangalore High Court wants to know whether this intervention in Kollam has given results, and they want to see, okay, what can we expect if we try something like this, they should be able to assess what is our system, how well is our system performing today, how well is the new system performing, what are the benefits that we can see. So the metrics that should be part of this course metric selection should be quantifiable, because then we can have an objective assessment. Of course, you could try doing surveys and other elements, right? But we're saying that it is useful to have an objective metric that anybody can calculate, that should be doable with publicly available access to data, so that the burden of effort is as limited as possible. And it will still give you a directionality of impact assessment. So I want to just reframe what are fine and course metrics. Fine metrics are things that are available to system administrators. It is useful for internal stakeholders, but course metrics are available to the general public. You can use fine metrics to do a before and after comparison because you have the data at all points of time. But course metrics also allow you to compare across different case types, across different courts. So if you have done an intervention in Kollam, you might be able to compare what happened in Thrissur or Kottayam or any of the neighboring districts and see, okay, without this intervention, did something change? With this intervention, we can do a difference in difference. So it gives you a lot of tools to analyze how to do impact, and it's not restricted just to the IT system that you have access to. And it allows you to, and fine metrics will allow you to also track changes in inputs, whereas course metrics will only track changes in outcomes. And did it make any tangible difference to the lives of litigants? And these are all metrics that are available in the public domain. And because we have to rely on public domain data, they are most likely not going to be very detailed. You're not going to get very granular admin data, but you will get some information. And yeah, you can ignore that. Okay. So what are the metrics? We've been trying to study this problem for a while, and we have arrived at 5 metrics that we think are the most useful. So one is time to disposal. This is a common metric that everybody, there's a measure of efficiency for us. It is the time from filing to disposal, and it can be calculated. And that's the first one. The second one is the number of hearings, which for us is a proxy of cost. That's the total number of hearings that happen in a case. The third metric is the percentage of substantive hearings in a case. So we have a definition of substantive, which I will show you. But broadly, it is an indicator. It is a binary variable that tells you, did the case make progress in this hearing? Right? Was some judicial action taken? Was there application of judicial mind? And we take the total number of hearings in a case, and we take the numerator as the percentage of hearings that were substantive, and that's our metric. Then the fourth variable that we take is the time to first substantive hearing. And the fifth variable is the variability in the time between hearings. So if you think of the time to disposal is essentially 2 variables multiplied together. It's the total number of hearings multiplied by the time between hearings. Now, what we want to do is we want to understand what is the variability in this time between hearings to help you get a sense of whether the case trajectory is predictable or not in terms of the duration. Right? And I'll double click into each of these metrics later. So measuring time to efficiency, the most common way people do things is, they take a bunch of cases, they take the date of disposal, they subtract from the date of filing, and they give you the numbers. We think this is not very useful. And as an example, let's take like 10 cases, right? They all started in 2022, and we kind of do this math on July 1st, 2024. So you can see that 5 of the cases have gotten disposed. The time to disposal was 0.51, 1.5 for simplicity. But 5 cases have still not gotten disposed. So if you just take the time to disposal of the cases that have concluded, you might assume, okay, the time is 7.5 by 5, which is 1.5. But even if the next 5 cases concluded the very next day, your math would still be incorrect, because when you then take every other case also at 2.5, the average comes down to 2. And we know that these cases, by virtue of being pending, are almost going to take longer than the existing cases. It is almost like the Lindy effect, right? If it has survived for so long, it is likely that it is going to survive a little bit longer at least. So we need a way of including the pending analysis. And we have done a seminar earlier on survival curves and why survival curves are the right answer. So survival curves are a tool to model duration and to model time to duration. It's a duration model to measure the time for an event to occur. So for us, the occurrence of the event is disposal, and using that data across a wide number of cases, we're able to give you the probability of survival or 1 minus probability of disposal, right? You can look at it either way. So I'm going to take some time to explain the graph on the left-hand side. This is from the blog post, which is on our lead blog by Manivanan et al., published last year, on helping litigants make informed choices in resolving debt disputes, where we take the case trajectory across 3 different forums of Bombay High Court, DRT, and NCLT. And we say, okay, what percentage of cases were still undisposed? So the graph tells you the number of cases that survived, that were not disposed after a year. And for easy reading, you can take the 1 minus percentage number and you can say, look, okay, within a year, the probability of disposal of NCLT was close to 40% and close to about 15% in DRT and Bombay High Court. So we found this to be a very useful metric. And for ease of simplicity, the graph that you see now, because it is complicated to explain 1 minus disposal, we have just shown you the probability of disposal. And this is an increasing curve. We've done it across 2 courts and 2 case types. And you can see there is a faint green line here at 0.5 that tells you that the courts expect you to dispose of all of these cases within 6 months. And you can see that barring Bangalore, which has about 10% of cases disposed, and within MV cases, where both in Kochi and Bangalore, there's some small percentage, most cases take a really long time to get disposed. So if we believe that using survival curves gives you a good representation of both pending and disposed cases, and we measure them using this survival curve metric. Then our second metric is the number of hearings for disposal. We think number of hearings is a good proxy for cost. One, it's monetary because some lawyers charge for hearing. Second, for litigants, there is a loss of daily earnings if they have to spend the day in court. Then there's a physical travel, there's a physical effort involved, there's some amount of mental effort to keep track of what happened, ensure coordination. So for us, number of hearings is a reasonable proxy for cost. And you can see that these are just some stats. The average number of hearings for disposal across these 4 forums varies widely by case type as well. But the number of hearings, the same logic that we apply to why you cannot just take the disposed cases to evaluate time to disposal, the same arguments apply to number of hearings. So we ideally will be using survival curves to measure the number of hearings as well. And this would be measured as, within a year, how many hearings are you likely to have? Or within 2 years, how many hearings are you likely to? And that will help you sort of calculate and plan for costs or, the amount of effort that you need to spend in this case. The third metric is predictability. The third metric.
Sorry.
No. Okay. So our third metric is another version of a measure of predictability, which is the percentage of substantive hearings in a case. Okay. So recently, D.Y. Chandrachud made a statement, which is, I request the members of the bar to not seek adjournments unless really, with emphasis on the 2 really is necessary. This cannot become a tariq pe tariq court, and this defeats the trust of citizens. So everybody clearly recognizes that adjournments are a problem. And we've taken some steps to define it in a quantifiable manner. So in their article, How Substantial or Non-Substantive Hearings in Indian Courts, some estimates from Bombay. Manivanan et al. 2023 offer a definition of substantive hearings, which is hearings where there is application of judicial mind that move the case forward. Right. So there is a long sort of paragraph. I encourage you all to read the blog, and you can get the full definition. But I've just highlighted one line that kind of succinctly explains the core idea here. And now, over the last 1.5 years, we've developed the ability that just by reading the order text, we can almost automate this binary classification of substantive and non-substantive. So the first time we did it last year, we used a lot of interns and made them read everything and classify. And today, we've got good machine learning tools that do this for us. And we think this is very useful. Just some examples of how this varies. So in Bombay High Court, so this analysis in the blog was done for debt disputes. And in Bombay High Court, we found that 43% of the hearings were substantive, DRT was 82, and NCLT was 91. And when we did the same analysis in district courts, we found that the numbers are far lower. It was 24%, 40%, 33%, and 41% for Ernakulam and Bangalore across different case types. The reason for showing you these numbers is not a commentary on the numbers themselves, but to show you that this tool or these methods of analysis can be applied in a manner which is near universal, agnostic of court type. The only small caveat I can present here is that the meaning of substantive might change based on the case, and that might require some amount of changes. So in some specific case types, there might be specific procedures which are almost critical to how the case progresses. So we may have to alter that definition to a large extent, but the principle holds. And if you are able to explain what constitutes progress in a case, we can then identify what is substantive and do, we can apply these measures to a large number of cases and get good averages. The third one, the fourth metric is we have now talked to you about number of hearings. We've talked to you about what is substantive. And we posit that another very useful metric is the time to the first substantive hearing. So this will tell you what is the probability that you will get a substantive hearing within a certain period of time. So it's almost as if, how long does it take for a case to make some tangible progress or the first unit of progress in a case. And it could be cognizance, it could be admission. There are for different cases, what is substantive may change, and based on the availability of data as well. These are some graphs, again, from the same work from the previous blog post that I talked about, where for different fora, we not only map the time to first hearing, but we also map the time to first substantive hearing. And the fifth variable for us is another measure of predictability, which is the time between hearings. So this is the variability of the time between hearings across cases. So the reason for this is that, having some amount of predictability or having a semblance of predictability is quite useful when you are planning an activity. So let's say you had a commute and, you didn't know whether your commute was going to be 20 minutes or 2 hours. That makes it really hard for you to plan your day. So getting a sense of, okay, when is the next hearing going to be is very useful. Now, within a case, it is very difficult for you to say that, I can get a sense of when the next hearing is, because if it is an admission, if it is summons, if it is evidence, if it is arguments, based on the stage of the case, this could vary a lot. But if I was to take some metric that would allow me to analyze the time between hearings across cases, that would give you a sense of, okay, most cases have this kind of trajectory. Where does my case lie among them? So what we do is we calculate the median time between hearings within a case, and then we plot the distribution across all cases, and then we take the interquartile range as a measure of this. So to give you a sense, so the graph on the bottom left, if it was a very predictable court, right, you would expect that almost all the cases would have the same median time between hearings. The next graph, the middle one, is an indicator of very low predictability, which is you take all the number of cases and you will see that at every date range, you have one or more cases. So this is extremely unpredictable. You can't do much with this information except sort of give up in life. And the last one is almost what is likely to happen, right? This is a simulated normal distribution of 100 cases. And I'm using this sort of artificial data to give you a sense that the aim is to reduce the variability. So in the first explanation above, what you can see is that there's a left shift in the entire distribution. So you can see that the median has reduced. This is an improvement in efficiency. This is not really an improvement in predictability. The next graph below, where you can see almost, the distribution come closer towards the median, this reduces the interquartile range. We've taken the interquartile range because it is a non-parametric distribution measure. It's agnostic of the distribution. Okay. It's a non-parametric measure of spread. Right? Okay. So this is a decrease in the spread of the graph, and it increases, and there's an increase in predictability. So you can see that the IQR has sort of dropped from 31 to 11, and the last one is an increase in is a decrease in predictability. So you can see that the graph kind of spreads out. So ideally, what you want is that you want as many cases as possible to have some similar trajectory, so that that gives you confidence that, okay, so my case is likely to evolve in a similar manner. So just to sort of repeat, we had 5 measures, and all 5 of these measures can be calculated using public data. They can be calculated sitting at home. You don't need to go travel to the court forum, and you can now do these comparative analyses literally for any court. You just need to go to eCourts, get a small set of data, and you can run this analysis yourself. And we think this is useful. The way we do this is you can kind of double click into this data. So once you get the time between hearings, or if you get the time that a case takes, you can then do stage classification. You can classify hearings as substantive or non-substantive. And that'll also give you some insight into, how long did a case take at a certain stage, though that can't be automated. So stage tagging is, in our capabilities, still a manual process today. All our data is from eCourts. So what we do, like I said, is we take a random sampling of pending and disposed cases and construct these metrics. And I'd like to end the talk and sort of throw it out to the crowd to ask some questions of, look, are there other course measures that you think are available and are useful for us to, prepare a better toolkit to analyze this? And one of the things that you need to keep sort of contending with is, once you introduce an intervention, what is the frequency of evaluation? So you could argue that, okay, you should do, you should sort of measure all of these on a daily basis. But what is the sort of right gestation period for some of these to take place? At which point of time, you can study, for example, the new court in Kollam. Should you be looking at it in 3 months, 6 months, 1 year? What's the right sort of gestation period while these metrics settle? And of course, there are fine metrics that are internal to a system. And while we may not have access to them, we think every court system administrator should think of what are these fine metrics and how can we actually track them, and how can we introduce interventions that would make court reforms better, or at least improve their chances of success. And that's it. Thank you.